Okay, so welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us today. The Data Practices Office is a small office in the Department of Administration, and we are a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from both members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions, and we provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the webinar page where you registered. We also record our webinars, so if you miss part of today's webinar, or if you want to go back and watch it again or find a different one, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and I'll have another slide later on with more information on accessing those resources after the webinar. So if you would like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer. Bear with me here a moment while I share the file. Okay, you should now see a pop-up window and you can select the file and download it to your device. Again, if that does not work for you for whatever reason, you can always visit our website on the webinars page. If you scroll down to the bottom, the Potpourri webinar PowerPoints are there for you to download. All right, so today's webinar is another installment of Data Practices Potpourri, where we highlight some of the questions data requesters and government entities have raised in the past month or so. We'll also leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. If you do that, make sure you choose all panelists when you send in your questions, just so that we can all be sure to see them. And you can start sending them in now, or you can wait until the end of the presentation as well. And with that, let's go to our first question. So many government entities maintain email addresses as government data. So a frequent question we receive is whether these email addresses are public and if they should be provided to public data requesters. Entities are often hesitant to release data that contain email addresses for certain individuals. However, under the Data Practices Act, data may only be withheld from a requester if there is a state or federal law classifying that data as not public, So how are these emails classified? Some examples listed here are government employees' email addresses, emails from members of the public to various government employees, or emails that you have because they subscribe to a newsletter from your entity. So there is not a general classification for all email addresses a government entity maintains. So whether or not emails are public data will depend on whose email it is and why the government entity is maintaining it. So let's walk through the examples that I listed on the previous slide. First, we have government employee email addresses. So data about government employees are classified under Minnesota statute section 13.43. And under this statute, most data about government employees are classified as private. But Minnesota statute section 1343 subdivision 2A7 cited there classifies work location as public data and available to data requesters. So in Advisory Opinion 97049, the Commissioner of Administration noted that the work email addresses of government employees are work locations under this provision and are public data. So you can find the full text of this or other advisory opinions on our website. Next, we have emails from members of the public. So there is not one classification for all emails from members of the public. So we begin with the public presumption, right, in the Data Practices Act, which presumes that all data are public unless there's a specific provision classifying that data as not public. And that public presumption, by the way, is found in Minnesota Statute Section 1303, Subdivision 1. So we begin assuming the email addresses are public But depending on why you have the email addresses, you may not be under the public presumption because there may actually be a statute classifying them as not public. So, for example, if you have the email address of someone because they are receiving benefits from an agency, those addresses may be classified as private data under the Welfare Data Provision, Minnesota Statutes 1346 listed there. If you have email addresses because that individual was corresponding with an elected official, correspondence with elected officials are classified as private under Minnesota Statute Section 13601. So there may be a specific provision classifying the email as not public, but that's going to depend, right, on the content of the email and the reasons that you have it. So remember, if you are redacting data in response to a request, you do need to cite to a statutory provision classifying that data as not public. So check the statutes that are applicable to your specific data. And of course, if you have questions, feel free to contact us and we can discuss it in more detail. And the final example I have is emails collected because those individuals subscribe to a newsletter your entity maintains. So if the email address was provided to subscribe to a newsletter or an electronic periodic publication, those emails are classified as private under Minnesota Statute Section 13356. And this section classifies contact information provided by an individual as part of a notification service or publication, such as a newsletter, and those are private. So as you can see, the classification is really going to depend on why you have the email address. If there is a statute that covers the reasons why you have the email, then that statute's classification applies. Otherwise, the public presumption applies and the requester can access those email data. All right, our next question here is a difficult one that is coming up more often. So government employees are often including their pronouns in their email signatures, and some email systems allow employees to display their pronouns alongside their name. There may be other locations where pronouns also come up, including just, day-to-day communications and writing. So what is the classification of an employee's personal pronouns? So there is a lot to consider here. So first, data about employees, as we mentioned earlier, is classified in Minnesota Statute Section 1343. And Section 1343 classifies data on individuals maintained because they are an employee as private, unless explicitly classified elsewhere as public. And public data elements for government employees are listed in Minnesota Statutes 1343 Subdivision 2. So this subdivision does not state pronouns are public data. So following this analysis, pronouns would be classified as private data about the employee under Minnesota Statute Section 1343. However, the definition for data on individuals states it does not include identifying data where the data on the individual is incidental to the data and the data are not accessed by the name or other identifying data of any individual. So incidental data on the employee would not be data about that employee. Any data that are incidental would not be classified as private under Minnesota Statute Section 1343 and would just fall under that public presumption. So this will be a judgment call for your entity, of course, since you know your data best. Are the pronouns that are responsive to your data request incidental to the data, or are the data accessed by the pronoun or the employee name? So under this analysis, a list of your department's employees and pronouns may be classified differently than the use of a pronoun in an email, for example. So take a look at your responsive data and consider the context of the data to determine whether they are incidental or not. And one final note on personal pronouns, as you determine whether they are incidental or not, or whether they need redaction, you may wish to consider whether the employee is voluntarily disclosing their pronouns or whether the pronoun data is something your entity requires. This may impact your risk assessment when you determine whether to redact those data or not. All right, so a recent question we've received is regarding law enforcement and Minnesota Statute Section 1380, which is titled Domestic Abuse Data. So here, a member of the public requested an incident report where officers responded to a domestic call. Minnesota Statute Section 1380 classifies domestic abuse data as confidential. So is this entire report confidential? So let's take a step back just to talk about law enforcement data generally. So law enforcement data are classified under Minnesota Statute Section 1382, which states that data are confidential when part of an active criminal investigation, but are public when the investigation is inactive. So for this question, if there was no investigation or charges, the data are public, but the domestic abuse provision in 1380 states that all data maintained by law enforcement that are created or collected pursuant to the Domestic Abuse Act are classified as confidential until an order for protection is served. So once that OFP is served, then the data are classified under 1382. So you'll have to determine whether the data you have were created pursuant to the Domestic Abuse Act, and if so, whether the OFP has been served. So for this question, if the data are collected pursuant to the Domestic Abuse Act and the OFP has not yet been served, then yes, the data are confidential under Minnesota Statute Section 1380. But once that order is served, then the data are treated under 1382. However, general law enforcement data about responding to domestics or even violations of OFPs do not fall under this section. They are classified under Minnesota Statute Section 1382. So for the initial question, we were talking about an incident report. So an incident report is not data collected pursuant to the Domestic Abuse Act. So here, the data would be classified under Minnesota Statute Section 1382 and are public unless there is an active criminal investigation. And just a note that under 1382, it is possible that victims may qualify for protection under Minnesota Statute Section 1382, Subdivision 17, which would make the data about the victim private even when the investigation is inactive. So many government entities have employees who are members of a union or work under an employment contract negotiated by a union. So union business agents will sometimes contact the government entity and ask for different data, such as addresses or information on benefits enrollment or other data. So the larger question is, what data on employees can a union access? So in this question, the union rep is asking for data on government employees. So we start again at Minnesota Statute Section 1343, which classifies data about individuals the government maintains because that individual is or was an employee, applicant, volunteer, or independent contractor. And subdivision 4 in 1343 states that data maintained about employees of government entities are classified as private. It does call out specific personnel data that have a public classification in subdivisions 2 and to some extent subdivision 3 as well, which are public data about applicants for employment. So this came up earlier, right, when we were talking about work email addresses. So the public data are available to anyone for any reason. So if the union rep is asking for public data listed in 1343, subdivisions 2 or 3, they can get that data. But all other data about the employee are classified as private under this provision. And private data are only available to those in the government who have a work assignment to see it, the subject of the data, anyone authorized by the subject, or anyone authorized by statute. So under these access restrictions for private data, the union rep can get any private data about the employee only if the employee provides informed consent or if there is a statute permitting union access to this personnel data. So is there a statute? Let's look at Minnesota Statute Section 1343, Subdivision 6. It states that labor organizations may access private personnel data if the responsible authority of the government entity determines that providing the data is necessary to conduct elections and implement the provisions of Chapter 179 and 179A, which are the Minnesota Labor Relations Act and the Public Employment Labor Relations Act. So we do have some statutory sharing here for the data classified as private. So the union rep may access any public personnel data, and under Minnesota Statute Section 1343, Subdivision 6, they may access private personnel data if the responsible authority for the government entity maintaining that data determines that the union needs the private data to carry out its protected activities under Minnesota Statutes 179 and 179A. So I do want to note that there is some legislative language that will change some of these data sharing provisions in Minnesota Statute Section 1343. So currently, as I mentioned, government entities may share private personnel data if the union needs it to carry out certain functions. And under this new language, the sharing turns from permissive, right, meaning the government may share it if it chooses to do so, to required. So the legislation also indicates data must be shared with the union to process grievances and classifies some other data. So this new language passed in the Senate on April 25th, in the House last week, and it is headed to conference committee. So for more information and other updates, please sign up for our newsletter if you haven't already done so. We will send out some legislative updates about data practices and the open meeting law at the end of the legislative session. And you can watch out for our July webinar where we'll recap legislative changes as well. Okay, let's take a look at a scenario involving body cameras. So an entity receives a data request for a copy of a body camera video from a data subject. The requester appears in 5 minutes of the 60-minute recording. So the question is, does the entity need to provide all 60 minutes of video data with applicable redactions, or can the entity provide only the 5 minutes where the subject appears, again with any needed redactions, and trim away the rest, the 55 other minutes of the video? So to look at body camera data more generally first, unless they were used as evidence in court, inactive body camera data are classified by Minnesota statute section 13825 as private or non-public data. 13825 applies to body cameras worn by a peace officer and maintained by law enforcement. If the data are part of an active criminal investigation, then they are classified as confidential under Minnesota statutes 13822 subdivision 7. Otherwise, we're in Minnesota statutes 13825, which classifies most of these data as private or non-public. And remember, private data are only available to those employees at the government entity whose work assignment requires access, anyone authorized by statute, and the data subject, or anyone authorized by the data subject. So the question here is, who is the data subject and what can they access? So this is inactive data. So we're under Minnesota statute section 13825, and 13825 subdivision 4A defines who is a data subject in body camera data, which in any individual, quote, whose image or voice is documented in the data. So in other words, individuals are data subjects of body camera data when they can be seen or heard in that data. And section 13825 subdivision 4B describes the access procedures, which states that the individual who is the subject of the portable recording system data has access to the data. So in short, an individual has access to the specific data in which they are the subject, not all the data contained in a video or recording. And remember that the Data Practices Act classifies data elements, not documents or full files. So someone can be the data subject here for portions of a recording only. So an individual can access body camera footage where they are the data subject, and they are only the data subject if they can be seen or heard. So going back to the initial question, whether the law enforcement agency needs to provide all the minutes of a video with redactions or not, based on the access language in 13825 subdivision 4, they should only get the portions of the video where they can actually be seen or heard. So in this question, that was the 5 minutes total, right, out of the 60-minute recording. So the law enforcement agency would provide the 5 minutes of data where the individual is actually the data subject. As you can see, Minnesota statute section 13825 provides different analysis for who is the data subject than the rest of the Data Practices Act. So if you are working with inactive body camera data, take a look at 13825 subdivision 4 and feel free to contact our office with questions. We did do a recording of a body camera webinar that is up on our YouTube page as well, and that provides a good overview of these requirements as well. We do often receive questions about the Data Practices Act regarding access to data on individuals or other topics that are addressed in the administrative rules. So if you are interested in the rules, I did want to include a quick plug here. Minnesota Rules, Chapter 1205, are the administrative rules promulgated by the Commissioner of Administration on the Data Practices Act, and a link to the rules is provided here. So these rules provide guidance on provisions in Chapter 13 related to private data on individuals, access to data on minors, duties of the responsible authority, and more. So These rules were last adopted in 1981, and the language of Chapter 13 has changed quite a bit since then. So, as a result, our office is working to update these rules, and we do welcome your feedback and insight in order to make these rules better. So, the link provided here is to our rulemaking page, and that's where we'll provide updates on the process and opportunities to provide your feedback. So, please bookmark that page, check it out in the future, or you can also sign up for our rulemaking email listserv to get further updates, excuse me. All right, so those are our questions today. We are going to take a look at some of yours. So if you would like to send in a question, remember to send them to all panelists through the Q&A panel so that we can be sure to see them. A few reminders on this slide. The slide deck is available on our website, and you can also access the recording on our YouTube page in the next day or two. And in just a moment here, I am going to put an evaluation in the polling panel. It should pop up for you. If you could please fill that out before you leave the webinar today, that would be great. Just let us know how we did, what other topics you'd like to see in the future. We do want to make sure that these webinars are helpful for you, so any feedback you have is greatly appreciated. So I'm going to open up that poll, and we will get started answering your questions in just a moment. Thank you. I'm not seeing any questions as of yet in the Q&A panel, so if you'd like to ask a question, please feel free to do so. We will monitor that for the next few minutes, and if you do not have any questions, please feel free to fill out the polling panel so we have that feedback. That's greatly appreciated, and have a great day. While you're thinking, if you are thinking of a question, I'll just hop over to the next slide. If you don't have any questions today, of course, feel free to contact us in the future if you have any questions. Our phone number is available there, email, website, Twitter. Just feel free to reach out. We are more than happy to answer any questions as they come up. Thanks, everyone. Have a great day. I am seeing a few questions come in, so myself and my colleagues will start to look at those. The first question I have here is a body camera question. So under 13825 subdivision 4B, it says an individual who is the subject of portable recording system data has access to the data, including data on other individuals who are the subject of the recording. If the individual requests a copy of the recording, data on the other individuals who do not consent to its release must be redacted from the copy. Is it correct to read that as if a data subject requests inspection access, they get access to the full unredacted video? Yes, that is our read as well under 13825 subdivision 4. Inspection access is different from copy access for body camera footage, and this is unique, specific to body camera footage in the Data Practices Act. If a data subject requests inspection of that footage, they may inspect the footage without redactions, but if they want a copy of that footage, you do redact any other individuals who have not provided consent except for on-duty police officers. So again, that inspection versus copy access will be different for those data subjects. Thanks.
We have another question that came in here. It asks, some data requests can take a really long time. What does the law say about timing for them to be fulfilled? So the timing or the response time that's required for government entities to respond to a data request will depend on the type of request. For a data subject request, so if a person or an individual is asking for data about themselves or their minor children, you have 10 business days to respond. For every other type of request, so a member of the public request, you have a reasonable amount of time. And what's considered reasonable will depend on the amount of data that's responsive, maybe whether there's redaction required. And so there's not a set time frame there. And long requests or really large requests might take a long time to respond. As a best practice, what we'd say is just stay in touch with your data requester, and let them know that you're working on the request. And if you have an estimated time frame or you're able to produce data on a rolling basis, those things can be helpful in managing expectations and responding to those requests.
Okay, we do have another question here that says, when privacy concerns come in from members of the public to various agencies, is it appropriate for the agency to refer the public to you, or do you prefer we send them someplace else? Well, I would say it depends. It kind of depends on the type of privacy concern that's coming up. If it's a privacy concern related to data that your agency or your entity is maintaining, or there's other concerns about the security of data, that may be a good question or issue to refer to your data practices compliance official within the entity, who is responsible for handling concerns about data practices and the use of data. And so that may be something that you would be obligated to handle internally as you're working on some of those issues. Alternatively, if it's a broader, someone is concerned about the classification of data or just data practices generally about various classifications, you can of course direct them to our office, and we are happy to answer any questions related to that privacy concerns, or direct them appropriately, maybe as need be. But we do answer questions from members of the public and can help address concerns at different times too. So it really depends. And so I think if it's, again, if it's dealing with the data you're maintaining, or data maybe being improperly disclosed, you may have to handle that internally with your data practices compliance official. But other broader, more general questions, you can certainly refer to us, and we can see how we can best help that individual. Okay, there is another question here asking, where is the webinar regarding the body-worn camera on the website? And so it's the video itself is not on our website, but if you are on our homepage, you can go down to the very bottom. There's a header there that says connect with us. And if you click on the YouTube icon there, all of our past webinar videos are on the YouTube page for us. So if you land on that YouTube page, I think you can find it under maybe the law enforcement, or it might be under the Potpourri playlist. But I think if you just kind of poke around on the YouTube page for a little bit, you should be able to find that body-worn camera webinar that we did about a year ago at this point. I think it was in April 2022. So if you look kind of around that time, you should be able to find that. But those are all posted on our YouTube page.
Yeah, Casey and I was just poking around as well, and you were incredibly correct. It is April 2022, and it is a data practices potpourri video. So you can find it on the YouTube page under the potpourri playlist.
We have more of a comment here, but there's a DPCO that gets lots of questions from members of the public or parents regarding what local government entities can or cannot do. And the concern is this DPCO doesn't want to be interpreting statutes on behalf of members of the public. And, I understand where you're coming from there. When as a DPCO, there's members of the public reaching out to you, asking questions about what can be done. We deal with that at our office too, and we always tell people we can't give them legal advice. And so if they want legal advice, they have to consult legal counsel, and we just offer technical assistance, and we try to answer those questions as best we can. And so just being upfront about what you can and cannot answer, and that you aren't providing legal advice, I think that's helpful.
Yeah, and I do want to just follow up on kind of that privacy concern question. There is a comment in the Q&A here that, just a reminder that public entity heads must report instances in which not public data may have been accessed by or provided to a person without lawful authorization to the legislative auditor under Minnesota statutes. section 3.971 subdivision 9, that is correct for entities that are subject to review by the legislative auditor. So typically state level entities. So if you are a state level entity and you have disclosed not public data to someone who isn't authorized to receive it, you do have to submit a report to OLA, or notify OLA that has occurred, which is a little bit of a broader reporting requirement than the data breach notification requirements in Chapter 13. But that is a great point. So if you are a state level entity and you have an issue where you have disclosed not public data to someone who's not authorized to receive it, you do have to report that to OLA. So that's a great follow-up point. Thank you.
Another question here. Does a notice to a minor about their right to have their private data withheld from their parent need to be in writing, and is there an age limit? So there's Minnesota Rule 1205.0500. Again, that's 1205.0500. It's called Access to Private Data Concerning Data Subjects who are minors. That rule sets out the procedures for a minor requesting that their parents be denied parental access, and then the considerations that the entity needs to review in making the determination on whether to honor that request. And so the factors are laid out there. There's a 5-factor list that will guide your government entity in deciding whether that choice is in the best interest of the minor. But it does say that the written request of the minor shall set forth the reasons for denying parental access. And so it does imply that that request will be in writing. There isn't an age limit for the minor in there. It just says one of the factors is whether the minor is of sufficient age and maturity. And that'll probably depend on the minor. And so that's something you as an entity need to consider when evaluating those requests.
I want to thank everyone for their great questions. We are at time right now. If we were not able to respond to your question, we will reach out and follow up to make sure you have the information you need. Thank you so much, everyone, for attending our Potpourri webinar today, and I hope you have a good rest of your day.